Hello friends, today we will be studying about the recent Supreme Court judgment regarding minority status of the Aligarh Muslim University. First, we will study about the recent Supreme Court judgment. We will analyze the judgment and study the main points of the judgment. Then we will see the brief timeline of events leading to the judgment. After that, we will study the implications of minority status for the Aligarh Muslim University. After that, we will study a previous case, that is the St. Stephen's College case of 1992, in which minority status was given for the St. Stephen's College. But in this case, the AMU, the Aligarh Muslim University, after granting of minority status to St. Stephen's College, the Aligarh Muslim University also started claiming minority status, and several arguments were given by the center against the minority status for AMU, and the AMU also gave its counter arguments claiming minority status in court in the St. Stephen's College case. And it was said by the court that it was argued by the center that since St. Stephen's College is a private college and it has not been established by any statute, so it can claim minority status. But since the AMU was established by a statute, it must maintain its secular and national character, and the AMU cannot claim minority status. And in this St. Stephen's College case, since minority status was granted to this St. Stephen's College, it was allowed to admit 50%. It was allowed 50% reservation for the students of minority Christian community, and also it was allowed autonomy in its admission process. Then next we will be studying about minority institutions and minority communities in India. After that, we will be studying the constitutional provisions related to minorities like Article 28, 29, 30, Article 350, 350A, 350B, etc. And finally, we will be doing a practice question on these topics. Now we start with the recent Supreme Court judgment regarding the AMU minority status. On 8th of November 2024, a 7-judge bench of Supreme Court overturned its earlier judgment of 1967 in the Aziz Basa versus Union of India case. Now, what was the Aziz Basa judgment? In the Aziz Basa judgment of 1967, the court had stated that since the Aligarh Muslim University had been established by an imperial law of 1920, so it could not claim minority status. Since it was established by an imperial law, it was a central university and it could not claim minority status. This was said by the court in the 1967 Aziz Basa judgment. And the court further said that the Aligarh Muslim University was neither established nor administered by the minority community, and hence it could not claim minority status. Now this judgment, it was overturned in the recent judgment of 8th of November 2024. Now what did the court say in this judgment, in the recent judgment? In the recent judgment, the court said that if any institution is established by a central government act, in case of the AMU it was the imperial law of 1920, if any institution is established by a central government act, we cannot say that it is not a minority institution. Just because the AMU was established by a central government act, that is the imperial law of 1920, we cannot say that since it was established by imperial law, it is not a minority institution. So AMU can claim minority institution status according to the recent judgment. Now the court asked 3 judges to prepare guidelines regarding criteria for defining minority institutions. So the court constituted a 3-judge bench to define the guidelines and criteria, to prepare the guidelines and criteria for defining what constitutes a minority institution. Then the third point is, in the recent judgment, the court said that for an institution to be a minority institution, it only needs to be established by the minority community according to the Article 30 of the Constitution. So Article 30 of Indian Constitution says that for an institution to be a minority institution, it needs to be established by the minority community. But the court says that it doesn't need to be administered by the minority community. So the only requirement is that it should be established by the minority community. It does not need to be administered by the minority community. This is not an essential requirement for an institution to claim minority status. Now we will be studying the four major points in the recent judgment of the court on 8th of November 2024. Now the first point is that since the AMU, the Aligarh Muslim University, was established under the imperial law. Earlier there was the Mohammedan Anglo-Oriental College that had been established by Sir Syed Ahmad Khan, and the name of this college was changed to Aligarh Muslim University by means of the imperial law of 1920. So AMU was established under imperial law. This does not imply that it was not established by the minority. So just because it was established by imperial law, we cannot say that it was not established by minority. If any institution is established by a central government act, then we cannot say that it is not a minority institution. So the court has overturned its earlier 1967 judgment. Then the next point is that the law was made to establish the university. The imperial law of 1920, it was made to establish the university. It is inappropriate to say that the university was established by parliament. So in the 1967 judgment, it was said that any institution established by the parliament, it cannot claim minority status. Any institution established by parliamentary law cannot claim minority status. But now this has been overturned, and the Aligarh Muslim University was established under the Aligarh Muslim University Act by the imperial law of 1920. And it is inappropriate to say that it was established by parliament. It was established by a parliamentary law. Now the third point the court said is that in order to know who established the institution, we need to know whose brain was behind establishing the institution. So in case of the AMU, its predecessor was the Mohammedan Anglo-Oriental College, whose name was changed to the Aligarh Muslim University in 1920. So the brain behind establishing the institution was Sir Syed Ahmad Khan. The imperial law was based on, so the establishment of AMU, it took inspiration from Sir Syed Ahmad Khan. So his brain was behind establishing the institution. So the court has said in order to know who established the institution, we need to know whose brain was behind establishing the institution. Who got this idea? Where did the money for buying the land for the institution come from? And who got the money? Did the minority community help in this? So all these points need to be considered to determine whether an institution was established by the minority community or not. The fourth point stated by the court is, if an institution is established by a member of the minority community, it will be deemed to be a minority educational institution. So in this case, since the predecessor was the Mohammedan Anglo-Oriental College established by Sir Syed Ahmad Khan, who was a member of the minority community, so the AMU can claim minority status. It is not essential that the administration of the institution should also be with the minority. So the only requirement under Article 30 of the Constitution is that it should be established by a member of the minority community. But it is not essential that the administration of that institution should also be with the minority for the institution to claim minority status. Then the fifth point is, in the recent judgment, the court constituted a 3-judge regular bench of Supreme Court. It has been asked to prepare guidelines regarding the criteria or requirements an institution should fulfill to be considered a minority institution. So these 3 judges will prepare the guidelines which will determine the requirements that an institution should fulfill to be considered a minority institution. These were the 4 main points of the recent judgment of the Supreme Court. A point to note here is that on 8th of February 2024, The Supreme Court had reserved this judgment, and finally on 8th of November 2024, it delivered the judgment. Now court had to deliberate on two main points in this judgment. The first point was, what are the criteria for giving minority status to any educational institution? On what basis should we give minority status to any educational institution? As we have seen, the court had constituted a three-judge bench to determine the guidelines for giving minority status to any educational institution. The second question that the court had to deliberate on in this judgment was, can an educational institution established under any law made by Parliament get minority status under Article 30 of the Constitution? So, as we have seen in the earlier 1967 judgment, the court had stated that since AMU was established under a law made by the Parliament, that is the Imperial Law of 1920, it was a law made by the Imperial Legislature, similar to the Parliament of today. So since the AMU was established by a law made by Parliament, it could not get minority status. This was stated in the earlier judgment of 1967. But in this judgment, the court had stated that just because an educational institution is established under any law made by Parliament, it cannot be denied minority status. So this was a question considered by the court. Can an educational institution established under any law made by Parliament get minority status under Article 30 of the Constitution? So in this judgment, court had said, yes, it can get. Now, Supreme Court emphasized that an educational institution must be established by a minority community to qualify for minority status under Article 30. This we have already seen. This involves examining who initiated the idea of the institution. So in case of AMU, it was Sir Syed Ahmad Khan. And whether it was intended to primarily benefit that community, whether the AMU was intended to primarily benefit the members of the Muslim community. So these were questions that the court deliberated upon. Now this AMU, we know it was established under the 1920 Imperial Law. Now Supreme Court decided to examine where the idea of the institution came from. And Supreme Court came to the conclusion that the idea came from Sir Syed Ahmad Khan, from the Mohammedan Anglo-Oriental College established by Sir Syed Ahmad Khan. Now, the Supreme Court has overturned its earlier ruling of 1967, and Supreme Court has said that just because an institution is established by a law made by Parliament, we cannot deny it minority status. This is what the judgment was, and a three-judge bench has been constituted to prepare guidelines on the requirements that are needed to call an institution a minority institution. For an institution to get the status of a minority institution, these three judges are going to determine the guidelines and criteria. And on that basis, minority status is going to be granted to any institution. So as yet, court has not finally said that AMU is a minority institution. The court has only cleared the path. The court has only said that just because AMU was established under a parliamentary law, under an imperial law, we cannot deny it minority status. This was the judgment. Now the court applied a twofold test. The first test was identify the brain behind the establishment of the institution. So how do you identify the brain behind establishment of the institution? By reviewing the correspondence of that time, by reviewing the documentations that reflect the intentions of the founders of the institution. Then second test the court applied was assess whether the administrative structure of the institution, that is the board or the management of the institution, whether the administrative structure of the institution affirms its minority character. Whether the board and the management that is administering the institution, whether it affirms the minority character, whether it serves to protect and promote the interests of the minority community. So this was a twofold test applied by the Supreme Court in its recent judgment. Now we will come to the timeline of events leading to the recent judgment of 8th November 2024. Now first in 1875, an institution called Madrasatul Ulum Musalman-e-Hind, it was established by Sir Syed Ahmad Khan. It was a kind of school. There was no higher education in this, and 2 years later it was upgraded to college level and it was named as Mohammedan Anglo-Oriental College. Then in 1920, the imperial law was passed and the Mohammedan Anglo, the MAO was transformed into the Aligarh Muslim University. And the Aligarh Muslim University Act was passed, giving statutory status to the Aligarh Muslim University. And the name of MAO was changed to Aligarh Muslim University. Then in the year 1951, end to the provision of giving compulsory religious instructions to Muslims. So earlier compulsory religious instruction was being provided to Muslims, but this practice was ended in the year 1951. Why was it ended? Because Article 28 of our constitution, it says that any institution which is aided by the state, which is receiving aid out of the state funds, any institution which is receiving aid out of the state fund, it cannot, in that institution compulsory religious instruction cannot be imparted. If any institution is receiving aid out of state funds, then religious instruction can be provided, but it cannot be made compulsory. So compulsory religious instruction cannot be provided in any institution that is receiving aid out of the state fund. So since AMU was receiving aid out of state funds, compulsory religious instruction could not be provided in AMU. So in 1951, the provision of giving compulsory instruction to Muslims, it was ended. Now non-Muslims were allowed to join the university court. Now university court was the supreme governing body of the Aligarh Muslim University at that time, and earlier only Muslims were there in this supreme governing body, and after 1951 non-Muslims were also allowed to join the university court. And the visitor, a role held by the President of India, replaced the university's rector, Lord Rector. So earlier the university had a Lord Rector, but now after 1951 this Lord Rector, it was replaced by the visitor, which was a role to be played by the President of India. Now this was the first amendment in the AMU Act. Compulsory religious instruction was ended and the Lord Rector was replaced by visitor, that is the President of India. Then in 1961 another change was there, another amendment. The powers of the Executive Council of the AMU, they were expanded. So the powers of the Executive Council of the AMU were expanded, and the authority of the University Court, that was the supreme governing body at that time, the authority of this University Court, it was diminished. As we have seen in 1951, non-Muslims were also allowed to join the University Court, and in 1965 another change was made. The University Court's authority, it was diminished, and the Executive Council's powers were expanded. So in a way, the Aligarh Muslim University was assuming a more secular character by means of these amendments of 1951 and 1965. Then an important thing happened in the year 1967. Now what was this thing? In 1967, a petition was brought before the Supreme Court challenging these two earlier amendments of 1951 and 1965. So the members of the community, they challenged the members of Muslim community challenged these two amendments in 1951 and 1965, saying that these amendments, they diluted the earlier AMU Act of 1920, and these amendments were against the interest of minority. So these two amendments, they were challenged before the Supreme Court. Now what did the Supreme Court rule in the 1967 judgment of Aziz Basha versus Union of India? So the court in a way ruled against the petitioners, and court said that Aligarh Muslim University will not get minority status. So in 1967 the court said Aligarh Muslim University will not get minority status. Why? Because the court said that since the Aligarh Muslim University was established under an imperial law, it was established under an imperial law of 1920, which was an act made by a central legislature or the parliament of that time when the British were ruling India. So since it was established under the imperial law of 1920, so it could not be given the minority status. So this was said by the court, in the famous 1967 judgment that AMU Aligarh Muslim University, since it was established by the Imperial Law of 1920, it was established by the imperial legislature of that time in British India, which is similar to the parliament of today, so it cannot get minority status. Now, next in 1972, Indira Gandhi tried to bring a new act to give minority status to AMU but failed. Then came the year 1981. In 1981, the central government amended the Aligarh Muslim University Act. In 1981, the then central government amended the Aligarh Muslim University Act and restored the minority status of Aligarh Muslim University. It restored the minority status, saying that Aligarh Muslim University was a minority institution and it was established to promote the culture and interests of the minority community. So in 1961, the central government amended the AMU Act to restore the minority status of the Aligarh Muslim University. Then in the year 2006, 50% reservation to Muslim students was provided in the PG medical courses because the central government had earlier restored the minority status in the year 1981. So after this amendment made by the central government, 50% reservation was provided to Muslims in PG medical courses in the AMU. Then the High Court became active. The Allahabad High Court, it became active because the judgment of the Supreme Court of 1967, it had been diluted by the central government by amending the AMU Act itself. The central government had restored the minority status of AMU. So now the High Court started taking action. What did the Allahabad High Court do? The Allahabad High Court struck down both the amendment of 1981, as well as the AMU's 50% Muslim reservation in PG medical courses. So 50% reservation in PG medical courses had been provided in the year 2006. The High Court struck down this. And the High Court also struck down the amendment that had been made in 1981, restoring the minority status of AMU. And on the basis of this amendment, 50% Muslim reservation had been provided in the PG medical courses. Then in the year 2016, many petitions were filed in the Supreme Court against the High Court judgment. As we have seen, the High Court had struck down the minority status granted to the AMU by the center by amending the AMU Act. So the Allahabad High Court had in a way reaffirmed the Supreme Court judgment in the Aziz Basha case. So after the High Court judgment negating the minority status of the AMU, many petitions were filed in the Supreme Court against this High Court judgment. And in 2019, Supreme Court referred the AMU case to a 7-judge bench because the earlier Aziz Basha case, it had been decided by a 5-judge bench. So now the Supreme Court referred the AMU case to a 7-judge bench in the year 2019. And finally, on 8th of November 2024, the 7-judge bench delivered its judgment. The 7-judge bench delivered its judgment on 8th of November 2024. Earlier, this 7-judge bench had reserved its judgment in February 2024, and it has finally delivered its judgment now on 8th of November 2024. So this was a brief timeline of the events leading to the recent judgment regarding minority status to AMU. Now the Supreme Court, in its recent judgment, we have already seen the Supreme Court says it has overturned the earlier Aziz Basha judgment, and the Supreme Court has said that just because an institution is established by a parliamentary law or an imperial law, we can't deny it minority status. And Supreme Court has said that for an institution to have minority status, it needs to be established by the minority community, but there is no essential requirement of the administration of that institution being from the minority community. There is no requirement that it needs to be administered by the minority community as well. And the Supreme Court has constituted a 3-judge regular bench to prepare guidelines regarding the criteria or the requirements that an institution should fulfill to be considered a minority institution. And detailed guidelines or directions regarding establishment and administration of minority institutions will be issued by this 3-judge bench. And while issuing these guidelines, factors like history of the minority institutions, conditions during which the institution was established, and the activities of the university administration, they will be considered. So the historical context as well as community intent, that will be considered while preparing these guidelines. Now these pictures are of certain alumni of the Aligarh Muslim University. The famous hockey player Dhyan Chand was alumni of the Aligarh Muslim University. Our former president Zakir Hussain was also alumni of the AMU. Now, what minority status entails for the Aligarh Muslim University? What is the implication of minority status for the Aligarh Muslim University? So, if an institution is given minority status, then under Article 15 Clause 5, minority education institutions are exempted from reserving seats for the SC, ST, OBC and EWS. So, under Article 15 Clause 5 of the Constitution, the minority institutions, they don't need to reserve seats for SC, ST, or OBC and economically weaker sections. And minority education institutions can reserve up to 50% seats for the members of minority community. So if Aligarh Muslim University is granted the minority status, it can reserve seats up to 50% for Muslims. In the year 2006, the Supreme Court had directed that status quo should be maintained. In the year 2006, as we have seen, the Allahabad High Court had ruled regarding the minority status of AMU. The Allahabad High Court has said that AMU will not have minority status. But the Supreme Court ordered that status quo should be maintained because appeal had been filed in the Supreme Court. So since the case was sub judice, the Supreme Court directed in 2006 that status quo should be maintained, and AMU at present does not have SC/ST quota because Supreme Court ordered status quo to be maintained. So reservations for SC/ST were not to be done in the Aligarh Muslim University. So at present the status is that Aligarh Muslim University does not have SC/ST quota, does not have quota for the SC/ST students. Because although the High Court had ruled that it is not a minority institution, and if it is not a minority institution, it should have reserved seats for SC, ST, OBC, EWS under Article 15 Clause 5. But since the matter was sub judice, it did not, the Supreme Court said that status quo should be maintained and it does not need to reserve the seats for SC, ST, OBC and EWS students. Now, if minority status is granted for the Aligarh Muslim University, the university's administrative structure would shift from its current setup. So at present there is an executive council of the AMU, and it is diverse in nature because it admits members from all communities. It has got a secular character. But if minority status is granted, then the composition of this executive council will change. Most probably it will have more number of Muslim members, and the AMU will be given more autonomy in its admission process. Most probably it will be admitting more number of Muslim students. So there would be a separate admission process for the AMU if it is granted the minority status. Now we are going to study about a previous case of 1992, that is the St. Stephen's College case. Now what happened in this St. Stephen's College case was that in this St. Stephen College was granted the status of a minority educational institution, and it was allowed to admit 50%, it was allowed to reserve 50% of seats for the members of the minority Christian community, and it was also allowed autonomy in its admission process. So minority status was granted to the St. Stephen's College in this case of 1992. And in this case, the question regarding whether AMU, Aligarh Muslim University, should be granted the minority status or not also came up before the Supreme Court. And when this question came up before the court, Center put forward its arguments against granting minority status to AMU, and AMU put its arguments for granting minority status to itself. So what were the center's arguments against granting minority status to Aligarh Muslim University? The center said that St. Stephen's College was founded privately, while the Aligarh Muslim University, it was established by an act of parliament, and the Aligarh Muslim University was receiving government funds. So since Aligarh Muslim University was established by an act of parliament and was receiving government funds, while this was not the case with St. Stephen's. So St. Stephen's could have minority status, but AMU should not have minority status. AMU should maintain its secular character and its national character. And it should not prioritize, the AMU should not prioritize one community's interests. These were the arguments given by the center against granting minority status to AMU. Now, what were the counter arguments put forward by AMU for granting minority status to AMU? So, AMU contended that exempting it from certain quota, that is exempting the Aligarh Muslim University from certain quota like the SC, ST or EWS quota, etc., does not harm public interest. It does not harm public interest if AMU is exempted from certain quotas. Is Article 30 of the Constitution provides minorities with special rights. So since minorities are provided special rights under Article 30, so exempting AMU from certain quotas does not harm public interest. Then senior advocate Kapil Sibal argued that minority rights contribute to societal equality because they balance the needs of diverse social sections. So he said that minority rights, they contribute to social equality, they are not against social equality. And and according to the St. Stephen's ruling of 1992, minority communities have a continuing right to administer the institutions that they establish. So whatever institutions are established by the minority communities, they have the continuing right to administer those institutions, irrespective of the government involvement, irrespective of whether they are getting aid out of the government funds or not, irrespective of the level of involvement of the government in their administration. So, according to the St. Stephen's ruling, minority communities, they have continuing right to administer institutions that they establish. So, according to Kapil Sibal, since AMU was established by the minority community, so the minority community has a continuing right to administer AMU, and AMU should be granted minority status. These were the counter arguments put forward by AMU. Now we will study about minority institutions and minority communities in India. According to the National Commission for Minority Educational Institutions, so National Commission for Minority Educational Institutions, this commission grants certificate to minority institutions. It recognizes minority institutions in India. So there was an act of 2004, the National Commission for Minority Educational Institutions Act of 2004, and this act, it recognized 6 religious communities as minorities at the national level in India. What were these 6 communities? Christians, Sikhs, Muslims, Parsis, Buddhists and Jains. Also a point to note here is that minority character of a community is recognized both at the national as well as state level. So a community may be minority in one state and may not be minority in another state. A community may be minority in one state and may not be minority at national level, or vice versa. For example, Hindus are a minority in Punjab, Jammu and Kashmir, Goa, Mizoram, Nagaland and Meghalaya. But they are not a minority at the national level. And they are not a minority in several states like Rajasthan or several other North Indian states. So this varies. Minority character of a community is recognized both at the national level as well as state level. Now this National Commission for Minority Educational Institutions has given minority institution certificate to 13,602 educational institutions till the year 2021. Now these educational institutions are other than schools. So they are mostly higher educational institutions. So other than schools, the National Commission for Minority Educational Institutions has given minority institution certificate to more than 13,000 educational institutions. And out of them, majority are Christian institutions, 7,550, and around 5,153 are Muslim institutions. Then regarding the data for schools, till the year 2020, the National Commission for Minority Educational Institutions has given minority institution certificate to more than 50,000 schools. And out of them, more than 27,000, nearly 27,000 are run by Muslims and nearly 16,000 are run by Christians. That is 15,808 are run by Christians. Now we come to a very important part of this video lecture, that is constitutional provisions for minorities. What are the provisions provided in the constitution for the minority community? Now the first provision, Article 28 of the Constitution, it deals with imparting religious instruction in educational institutions. So whether religious instruction can be imparted in educational institutions and whether it can be made compulsory or not. So the first point, Article 28 Clause 1 says that in educational institutions that are wholly owned and maintained by the state. So in educational institutions which are wholly owned as well as maintained by the state, no religious instruction can be imparted. Now the second point says in private educational institutions that are receiving aid out of state fund, if it is a private educational institution that is receiving aid out of state fund, then religious instructions can be imparted, but they can't be made compulsory. Also in private educational institutions that are recognized by the state but may not be receiving aid out of the state fund, in these also religious instruction can be imparted but they cannot be made compulsory. Then educational institutions that have been established under a religious endowment or by a charitable trust, but they are administered by the state. The state merely administers them. So state merely administers them and they are established under a religious endowment or a charitable trust. Example of these institutions are Arabic and Urdu schools, madrasas, mud schools, etc. So they have been established under a religious endowment or a charitable trust, but they are merely administered by the state. They are not funded by the state. They are only administered by the state. In such institutions like madrasas, mud schools, Arabic or Urdu schools, here religious instructions can be imparted and they can also be made compulsory. Because in these educational institutions, since the state is only administering them, merely administering them with the use of the funds from the endowment, with the use of the endowment funds, and the state is not spending the public money. So religious instructions, they can be imparted and they can also be made compulsory. So we see the case of AMU. In case of AMU, what is it? In case of AMU, it is receiving aid out of state funds. It is receiving aid out of state funds. So since it is receiving aid out of state funds, it comes in the second category, receiving aid out of state funds. So here religious instructions, they can be imparted but they can't be made compulsory. They can't be made compulsory. Now the 1951 amendment to the Imperial Law of 1920. We have already seen this. The 1951 amendment to the Imperial Law of 1920, it did away with the compulsory religious instruction to Muslim students, because under Article 28, since the AMU is receiving aid out of state funds, here religious instruction can be imparted but it can't be made compulsory. In India, compulsory religious instruction is prohibited in state-funded educational institutions under Article 28. Now we come to the next important article for safeguarding the rights of minorities. It is Article 29 that deals with protection of the interests of minorities. Now Article 29, it recognizes two types of minorities. It recognizes minorities on the basis of linguistic basis and cultural basis. So it recognizes two types of minorities, linguistic and cultural minorities. Now Article 29 Clause 1, it says any section of citizens residing in the territory of India or any part of the territory of India having a distinct language, script or culture of its own shall have the right to conserve the same. So any section of citizens having a distinct language, script or culture has the right to conserve the same. Now this right under Article 19 Clause 1 of the Constitution, it is enjoyed both by the minority community as well as the majority community. So both the minority as well as majority community, they enjoy the right under Article 19 Clause 1 to preserve their distinct language, script or culture. Now Article 19 Clause 2, it says no citizen shall be denied admission to any educational institutions maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language or any of them. So if any educational institution is maintained by the state or it is receiving aid out of state funds, no citizen can be denied admission on grounds only of religion, race, caste, language or any of them. So non-discrimination. This is the second provision of Article 29. Now we come to Article 30. Article 30 deals with the right of minorities to establish and administer the educational institution. So in case of AMU, this article becomes all the more important. It deals with the right of minorities to establish and administer educational institutions. Now Article 30 Clause 1, it says all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. So every minority community has the right to establish as well as administer the educational institution of their choice. Now Article 30 Clause 1A, Article 31A, it deals with the right to property of the minority community. So in making any law providing for the compulsory acquisition of property of an educational institution established or administered by minority, suppose an education institution is established or administered by a minority and the government wants to acquire its property. So in making any law providing for compulsory acquisition of property of any educational institution established or administered by minority referred to in clause 1, state shall ensure that the amount fixed or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under the clause. So if the state is going for compulsory acquisition of property of the minority educational institution, then the state has to provide due compensation. It has to provide adequate compensation, and also the state has to ensure that the minority educational institution is relocated elsewhere so that the purpose of providing education to the minority community, it is not compromised. So it should not violate the rights of the minorities to establish and administer educational institutions. If the state is acquiring property, if the state is going for compulsory acquisition of property, so state has to ensure that the rights of minority are not violated. Due compensation needs to be paid by the state, and the state needs to relocate the minority educational institution elsewhere, provide some land elsewhere, provide due support so that the rights of the minority community under Article 30 Clause 1 of the Constitution are not compromised. Then Article 30 Clause 2, it says that the state shall not, in granting aid to educational institutions, so when the state is granting aid to educational institution, it shall not discriminate against any educational institution on the ground that it is under the management of a minority. So state will not discriminate against any educational institution on the ground that it is being managed by a minority community while it is granting aid to the educational institutions, whether based on religion or language. So if a minority educational institution is being managed, is being granted aid is when the state is granting aid to the educational institution, it will not discriminate against the minority educational institutions. Then we come to the important cases. One is the St. Stephen's College versus DU case of 1992. This we have already seen. In this case, the court stated that the court recognized the minority status of St. Stephen's College, and the court stated that a minority educational institution can admit students coming from its own community up to 50% of its enrollment. So St. Stephen's College was allowed to admit students of the Christian minority community to 50%, and also it was given autonomy. In its admission process. Then we come to the next case, that is the TMA Pai and others versus State of Karnataka and others case. Now what happened in this case? The Supreme Court said it held that an unaided minority institution, so an unaided minority education institution, that is an education institution which is not receiving aid from the state fund, it is free to follow its own admission policy by holding its own entrance exam for admission, provided its admission policy is transparent and merit based. So an unaided minority institution can have its own admission policy, and it can have its own entrance exam. But the condition is that the admission policy of that unaided minority educational institution, it should be transparent and merit based. Also, the court ruled that an unaided minority education institution can fix its own fee structure. So the court ruled that an unaided minority education institution can fix its own fee structure provided that it does not collect capitation fee. So it can fix its own fee structure provided that it doesn't collect capitation. What is capitation? Capitation means the fee charged per head. So provided that the unaided minority education institution doesn't collect capitation, it can fix its own fee structure. Then Article 350 of the Constitution for safeguarding the rights of minority community. So Article 350 of the Constitution says that the language to be used in representations for redress of grievances. It says that if a person is presenting his or her grievance to the government, then the grievance can be presented in any official language. The grievance can be presented in any of the official language of the center or state. So this is Article 350. Then comes Article 350 Clause A. The Article 350 Clause A says the state government shall have facilities available to children of linguistic minorities. So children of linguistic minorities will be imparted education in their mother tongue till they reach the 5th standard. So till the children reach 5th standard, the state will provide facility for imparting them education in their mother tongue. Then Article 350 Clause B. According to Article 350 Clause B, the President shall appoint a special officer to investigate into the rights of linguistic minorities. So whatever rights are provided to linguistic minorities under the Constitution or under any parliamentary law, the President will appoint a special officer to investigate into whether these rights are being provided or not, whether there is a violation of these rights or not. So the President will appoint a special officer to investigate the rights that are extended to linguistic minorities under the Constitution or under any parliamentary law. And this special officer will submit a report to the President, and the President will place this report before the Parliament. So President will appoint a special officer to investigate into the rights that are provided to the minority communities under constitutional or parliamentary laws, and this officer will submit a report to the president, and the president will place this report before the parliament. So this was Article 350, Clause B of the Constitution. Now finally we come to a practice question regarding this topic. The practice question is, critically evaluate the recent Supreme Court judgment regarding the minority status to AMU. Also discuss the various constitutional provisions for safeguarding the minority rights. Now we have to critically evaluate, that is, we have to analyze both the positives and negatives of the recent Supreme Court judgment regarding minority status to AMU. So first we will see the positives. What are the benefits of the Supreme Court judgment regarding minority status to AMU? First, you will write the introduction to the question. In the introduction, you can briefly talk about the Supreme Court judgment, which overturns the earlier Aziz Basha judgment of 1967, and it says that just because any institution has been established under a parliamentary law, just because any institution is established under a parliamentary law, we cannot deny it minority status. And the Supreme Court, you can also talk that Supreme Court has said that for an institution to be granted minority status, it should be established by the minority community according to Article 30 of the Constitution, but there is no essential requirement that the institution also needs to be administered by the minority community. Also, the Supreme Court has constituted a three-judge bench which will prepare the guidelines regarding the criteria for identifying an institution as a minority institution. So this is what you can write in the introduction. Then after the introduction, you will write about the positives of the recent judgment as well as the negatives. First, we talk about the positives. The positives is that it is safeguarding the rights of the minority community, and this judgment is focusing on, it is going deeper, it is focusing on the historical intent also. On factors like the historical intent behind establishment of a minority institution, that is the idea behind establishing the minority institution. So court said that since the idea for establishing the AMU, it came from Sir Syed Ahmad Khan, who was a member of the minority community. Hence, the AMU can also claim minority status on this basis. And this judgment is talking about the community intent, the intent of the community. Whether the administration of the institution is such that it serves the interests of the minority community. We have to examine this question to determine the minority status of the educational institution. So it has in a way given a new framework. It has given a new framework for granting of minority status. It has given an inclusive interpretation. It has given a more inclusive interpretation of what constitutes a minority institution, and it has allowed for a reassessment of the AMU's status based on factors like historical intent and historical context and community intent. So this is a benefit. Then it has reaffirmed the legal autonomy of minority educational institutions, because this judgment says that just because the institution is established by a parliamentary law, we can't deny it minority status. So legislative recognition does not negate the minority character of an institution. It has challenged the previous interpretations in the Ajit Basha judgment, because Ajit Basha judgment had taken a narrow view, saying that just because the AMU was established under parliamentary law, it cannot claim minority status. Then other points, it has also given a broad interpretation. It has broadly interpreted the word established. Now AMU, we can say that it was established by the imperial law of 1920, but Supreme Court has interpreted the word established in a very broad manner. How? Supreme Court has gone further and dug into the idea behind establishment of the minority institution. Where did the idea come from? on whose motivation or inspiration did the imperial government, that is the then British government, on whose inspiration did the imperial legislature pass the AMU Act? So it was clear that the inspiration was from Sir Syed Ahmad Khan. So since the inspiration was from the Mohammedan Anglo-Oriental College established by Sir Syed Ahmad Khan, so hence we can in a way say that the AMU, it was established by a member of the minority community, and on that basis it can claim minority status. Now this is another point that you can include in the positives of the judgment. Then this judgment is going to give the minority educational institution more autonomy. It is going to give the AMU more autonomy in its functioning. Because if the AMU is granted the minority status, it will have autonomy in its admission process. It can admit the members of the minority community, that in this case the Muslim community, up to 50% of its total strength of students. So it will lead to upliftment of the Muslim community. It will help the AMU to align its policies with the interest of the Muslim community. Then the last point you can include as a positive is that this decision reinforces the constitutional rights of the minorities that are guaranteed under Article 30 of the Constitution. That is, Article 30 Clause 1 says that the minority community has the right to establish and administer the educational institutions. And this judgment, and by reaffirming the constitutional rights under Article 30, it prevents undue interference from the state laws, and hence it is going to promote educational diversity in India. It is going to promote the interest of the minority communities and promote educational diversity in India. A point to note is that Article 30, it guarantees rights to the minority community only, while Article 29 Clause 1, it guarantees rights to both the majority as well as minority community. Now we have seen the positives of the recent Supreme Court judgment. Now we will talk about what are the negatives of the judgment. That is, what are the adverse effects that it may have. The adverse effect it may have is, the counter argument we can give is that since the AMU is receiving aid out of state funds, so state is funding the AMU, and state, we know, it has a secular character. So if AMU is granted minority status, then it can admit up to 50 students, up to 50% of its total strength from the Muslim community. So this may deny the right of quality education to members of other communities. So this is a counter argument that can be put forth regarding this SC judgment. Now the next part of the question is, discuss the various constitutional provisions for safeguarding minority rights. What are the constitutional provisions for safeguarding minority rights? These we have already discussed in the previous slides. These constitutional provisions for safeguarding minority rights, they include Articles 28, 29, 30, 350, 350A and 350B of the Constitution. Article 28 talks about the minority, it talks about imparting religious instruction in educational institutions. We have already studied this in detail. It talks about whether the educational institutions, whether in the educational institutions religious instruction can be imparted or not. It talks about various educational institutions, three types, that is wholly owned and maintained by state, then private educational institutions receiving aid out of state funds, then private educational institutions recognized by state, and the fourth category it talks about is educational institutions that are established under a charitable trust or religious endowment and are administered by the state. So all this we have already discussed in these slides. Now, educational institutions wholly owned, maintained by state, no religious instruction can be given. In educational institutions receiving aid out of state funds, private educational institutions receiving aid out of state funds, we can give religious instruction, but we can't make it compulsory. Similarly, in the third category, private educational institutions that are recognized by state, you can give religious instructions but can't make it compulsory. Then educational institutions that are merely administered by the state, they are established under a religious endowment or charitable trust, but they are merely administered by the state, like the madrasas, muds, etc. Here, religious instructions can be imparted and they can also be made compulsory. Then about Article 29 of the Constitution, it talks about two types of minorities, linguistic and cultural, and it says that any section of the citizens residing in any territory of India or its part has the right to preserve its distinct language, script or culture. And Article 29 Clause 1 talks about the rights of both minority as well as majority community. And 29 Clause 2 says that no citizen will be denied admission to any educational institution that is maintained by state or receiving aid out of state funds on grounds only of religion, race, caste, language or any of them. Then Article 30 talks about the rights of minorities to establish and administer educational institutions. And 30 Clause 1A, it talks about the property rights of minority educational institutions. So if the state is acquiring the property of minority educational institutions, it needs to pay due compensations and it needs to ensure that if it is acquiring the property of minority educational institutions, the rights of minority educational institutions under Article 30 Clause 1, they are not compromised. That is, the state will need to take measures to relocate the minority educational institutions so that the rights of the students to study, the rights of the minority to establish and administer educational institutions, it is not compromised. So these are the constitutional provisions for safeguarding the minority rights. Now, in the first part of the question, that is critically evaluate the recent Supreme Court judgment regarding minority status to AMU. What do you write in the conclusion part? In the conclusion part, you can write that we need to balance the autonomy and accountability of minority educational institutions. So the need for autonomy and accountability needs to be balanced. We need to ensure that the rights of minorities are protected, but at the same time, we need to ensure that the quality of education is not compromised. And you can also write that the recent Supreme Court judgment is a positive step in the direction of guaranteeing the rights of minorities under Article 30 of the Constitution, but we need to ensure that there is a balance between autonomy and accountability of minority educational institutions. So in this way you can conclude the first part of the question. So in this video lecture we have studied about the recent Supreme Court judgment regarding minority status of AMU. We have studied the precedents, that is the Aziz Basha judgment, the timeline of events leading up to the recent judgment, what are the implications of the minority status for Aligarh Muslim University, the arguments and counter arguments that had been put by the Center and AMU in the earlier case of St. Stephen's College in 1992, and the various constitutional provisions for minorities along with the practice question. So with this we come to the end of this video. Thank you.